Welcome everyone. Just going to give it about a minute or two so all of the attendees can be admitted to the Zoom meeting.
It's kind of like waiting for popcorn to pop. Once the attendees joining are separated by a few seconds apart, we'll launch in. All right, well, I think we are, let's begin, and others can catch up as they join in. Good day and welcome everyone to our fourth webinar in the Trademarks in Canada series. My name is Mark Bernacki and I'm a partner in Smart & Biggar's Toronto office, and I practice primarily in trademarks and litigation. I'm joined today by my colleague, Daniel Anthony, who is counsel at Smart & Biggar's Ottawa office and also practices in trademarks and litigation. Importantly, Daniel is one of only a handful of IP lawyers in Canada with a wealth of experience in dealing with domain name disputes, takedowns, and more broadly, online infringement. And when I have a question regarding anything related to domain names, he's the first person that I call. Together, we will be your speakers for today's presentation on IP strategy from bricks to clicks. Now, before we begin, I'd like to deal with just a few housekeeping matters. In terms of timing, we're planning on our formal presentation to last for about 30 to 40 minutes, and it will be followed by an open and interactive Q&A session. As for those questions, you are welcome to submit your questions at any time during the presentation by typing them into the Q&A panel, which can be accessed by clicking on the Q&A button at the bottom of your screen. Please do not type your questions into the chat panel. We will not be monitoring that. And if you ask a question there, it might get lost. We'll try our best to address all the questions in our live session or in a follow-up email if we run out of time. And lastly, today's webinar is being recorded, and following the presentation, we will circulate an email with a replay link together with a PDF copy of the slides from today's presentation. And with that, let's get started with a brief introduction to Smart & Biggar. So hopefully you're already familiar with Smart & Biggar, but if you're not, here are a few highlights. We've been around for a long time. We're Canada's largest IP boutique with boots on the ground across the country. We have more registered patent and trademark agents than any other firm. We have more patents and trademarks filed than any other firm. We also have arguably the largest and most experienced and most successful group of IP litigators in the country. And importantly, we work collaboratively as a firm across all of our offices and practice groups. So when you retain any of us, you are effectively retaining our entire firm. But enough about us. Let's move on to today's topic. So in terms of an agenda, we've got a short but jam-packed agenda. First, we're going to introduce 3 common scenarios regarding online infringement. Next, we'll briefly review why it's important to protect your IP. We'll then turn to discussing 10 proactive tools that rights holders can use to avoid or mitigate risk. We'll then discuss a number of reactive tools that can be used once problems arise. And then we will return to revisit the 3 scenarios to discuss how these different proactive and reactive tools may have been applied. So, turning to the 3 scenarios, let me pass it over to Daniel to introduce the first 2.
Thanks, Mark. Scenario number 1. We call this one the domain name troll. Now, many of you will be familiar with cyber squatting. And in this particular example that we've drafted up, we have a brand owner that has cleared the availability of a new trademark. And they've also checked if the matching domain names are available. They then file their trademark as part of a strategy, perhaps in the home country, intending to expand to other countries through Parody or Madrid. And later, their IT group goes to get the domain name, perhaps a few weeks later, but it's gone. Someone's beaten them to it. What could they have done differently? What can they do now? Our second scenario, we call the counterfeiter. Now, there's all sorts of counterfeits out there. But in this scenario, we have a brand owner that's selling a new and popular consumer product. It's taking off. But now they're beginning to see counterfeits offered for sale, both online and it's getting into stores. They don't have their trademark registered yet. They don't have any copyrights. So what can they do? I'll pass it to Mark for the third scenario.
So thanks, Dan. The third scenario is the media pirate. And so here we have a brand owner who's selling video games. Now, this scenario can apply to virtually any company that owns media and copyrights. And in this scenario, the company learns that there is a Canadian operating a website that provides links for downloading pirated copies of those games, along with mods for that permit cheating in those video games. The website is hosted abroad, perhaps by a bad actor host, and the links lead to various cyber lockers. What options are available? Well, stay tuned to the end, and we will go over what some of those are. So before we get into the meat of the presentation, I wanted to spend just a little bit of time on why anyone should be protecting their IP. And if you're attending this webinar, you probably don't need any hints. The answer, of course, is because IP is valuable. But what many companies, even sophisticated ones, don't always appreciate is exactly what that value is and where it's derived from. And so if we look at this slide, how valuable is IP? Well, in 1975, it accounted for about 17% of the value of all S&P 500 companies. So it's nothing to sneeze at. That may, at that time, still have been one of the most valuable assets of many of those companies. But fast forward to today, it accounts for over 80% of their market value. And that number is only likely to grow. And that is a remarkable figure. And to drive this point home, I'm reminded of an observation that the CEO of Coca-Cola made some time ago. He said that if you took away all of Coca-Cola's trademarks and revealed their secret formula to the world, they would most certainly go out of business very quickly. But if you took away all of Coca-Cola's tangible assets and left it only with its trademarks and trade secrets, they would quickly rebuild and return to turning a profit. So with that, I'll turn it back to you, Dan.
Where is that IP value? Here's 6 examples, just to break it down a bit, but there's actually many others. So any business or legal advisor is likely aware that IP builds fences. It creates a market exclusivity. When you own a brand, let's say Coca-Cola, as Mark just said, you know that you're the only company that can use that name and all the goodwill that comes with it. And it lets you sell more products more easily. But in addition to that, you can enhance the price of your products and services. Now, my wife likes Nutella. And just last week, we were in the store looking for a jar, and it was about $7. But then she remarked, hey, the off-brand chocolate hazelnut spread that was right beside was only $3. So this wasn't just some 20% markup. This was 120% markup. So I asked, well, do you want to try the off-brand since it's so much cheaper? She quickly and emphatically declined that option. So that just shows you how you can really enhance price with a great product and a great brand. IP rights also allow you to buy, sell, and license IP much more fluidly and easily. They enhance your company valuation. A lot of stock prices can be influenced by the strength of the IP portfolio. They can serve as collateral and security, especially with newer companies. For example, in Canada, we have this big cannabis boom. And one of my cannabis clients, they certainly don't have necessarily a lot of security if you're a newer company, but your IP can be put up as collateral for a lot of these loans. It can also be a vehicle for tax optimization. It can be a marketing tool and much more. So these are some of the aspects of where the value is in IP. Now let's get into the meat of our presentation. What are some proactive tools that businesses can use to really harvest this value of IP? We've got 10 to walk you through. I'll do the first row and I'll pass it to Mark for the second row. So let's look at the first icon, the cloud, the idea. We want to be identifying the new trademarks and copyrights as they're developed. Businesses need to have a communication between a marketing and brand development and the copyright asset development and the legal side. Next, timely registration. As you're identifying these new assets that every business will inevitably be creating, should we register it? And when should we register it? It is so much better to have things in the pipeline for when problems occur. And in this presentation, we're focusing really exclusively on the online trademark and copyright problems. So much better to have those registrations in hand to deal with problems than to have a problem and say, oh, how can we deal with this? Well, we should get some registration so we can do anything at all, maybe. Next, proper marking. Putting that TM symbol, that R registered trademark, the C for copyright, it's a marketing tool to tell your customers, hey, this is exclusive stuff. And it also deters, good faith competitors saying, stay out of my area. We also want to ensure ownership. Copyright especially can be generated fluidly, collaboratively, outside contractors. It can be very difficult after the fact to piece it all together, identify authors. You want to be ensuring that as copyright is generated, you have the right assignments in place. You're identifying who made the work and when. And finally, on the top row, we have brand registry. An example is Amazon's brand registry. A lot of online marketplaces these days are allowing rights holders to declare their position as the brand owner and to get tools to track and enforce the IP on that platform. Essentially, these services are downloading a little bit to the brand owner, but it's better than the alternative.
So thanks, Dan. So turning to the second row. So the first icon there, we have requests for assistance, or RFAs. So RFAs are forms that are filed with customs that authorize border agents to seize goods suspected of infringing registered trademarks and copyrights and share information with the rights holder. RFAs list registered trademarks and copyrights owned by the party, along with other information that may assist border agents in identifying counterfeits. So that information might include who authorized importers are, suspected infringers or unauthorized importers, authorized and unauthorized ports of entry. RFAs have no government fee, and the only cost is a modest cost for counsel to create a strategic approach for you and to prepare and file the RFA with customs. They can be an important tool in collecting information about counterfeiters and stopping counterfeiters at the border. And importantly, if a company doesn't file an RFA with customs, border agents in Canada have no authority to detain suspected counterfeit goods or share any information about the shipment or importer with the rights holder. So turning to the next icon, we have anti-counterfeiting measures. So these are measures that companies can employ to make it harder to counterfeit their products or easier to detect counterfeits. Many different examples of anti-counterfeiting measures can be found in most paper currency. You may have special ink, unique fonts or special paper, microprinting, holograms, or unique serial numbers. Many of these measures can and are applied to products. Some of these measures can be public, like serial numbers and holograms, while others, like invisible ink, may be secret, which may make them more difficult to circumvent by counterfeiters. Next, we have technological protection measures, or TPMs. TPMs are measures that companies may employ to prevent copying of or access to copyrighted works. TPMs may include sophisticated measures like encryption, scrambling, descrambling, two-factor authentication, unique serial numbers, login codes, paywalls, just to name a few. They may also include unsophisticated but very effective measures, like the unique shape of a game cartridge that only plays on a corresponding game console. Importantly, the Canadian Copyright Act prohibits circumvention of TPMs, offering of TPM circumvention services, or trafficking in TPM circumvention devices. Further, the Federal Court of Canada has held that statutory damages may be sought for every work made available through a TPM circumvention device, and not just per TPM circumvented. And as a result, liability for TPM circumvention can add up quickly. Next are smart contracts. So these can be used by rights holders to enhance their IP rights by exercising more control over their supply chain. For instance, smart contracts may be used to prohibit dealers from purchasing authentic goods from unauthorized sources, or from selling authentic products outside of certain geographic areas. So such contracts can be useful in curbing importation and sale of gray market goods, which are things that are difficult to address on their own with trademark and copyrights due to things like the doctrine of exhaustion. And then the last proactive tool that we have here is monitoring the marketplace. And so the purpose of monitoring the marketplace is to identify problems so that you can respond to them in a timely and appropriate manner. Apart from causing a rights holder to lose sales and revenue, infringement can tarnish or dilute a brand and encourage other infringers to engage in the same activity. But if infringers know that you're monitoring the marketplace and enforce your rights, they may be less likely to infringe your rights and seek greener pastures. Finally, by monitoring the marketplace, a company may collect and preserve valuable information, such as instances of actual confusion, which may make it much easier to enforce their rights. So next, I'll turn it over to Dan to discuss some of the reactive tools that may be applied once a problem arises.
Thanks. No matter how much work you do to get your rights in place, mark things, get all the contracts, good brands get infringed. That's just a fact of life. And so there's a series of reactive tools that we can use. Now, Mark, on the next slide, we'll talk a bit about some of the traditional C&D and litigation tactics. But here's some tactics, some of which are really focused on the online world. So the first one is really a new thing for Canada from a trademark perspective, and it's expedited examination. Canada currently experiences an unfortunate backlog where we're waiting about 2 years to get our trademarks examined. But in May of this year, the office stated that if you meet one of 3 requirements, which is that you're ready to sue someone, or you've got a border enforcement issue to address, or you have online infringement to address, you can request that your application be expedited. And generally, we've been finding just in the first month or 2 of this program that when we file such a request, we get first office action within 1 week. So you can really accelerate examination when you do have an infringement. For copyright, Canada has always had the fastest copyright registration service that I'm aware of in the world. When you file a copyright in Canada, you get your registration number instantly in the filing receipt, and you get the registration certificate within 5 days, pretty much every time. So that's a great tool to just crystallize your rights as rapidly as possible when you're facing a real obstacle. Another tool is your standard opposition proceedings. So this is a traditional approach, but if there's a competitor or a third party that's perhaps got too close a trademark and there's collisions happening online and some infringement, you can certainly tie up their registration process by opposing the mark, whether it be to block that mark from ever being registered or simply to delay it substantially for a few years as leverage for negotiation. Then we have takedowns. Now, frankly, we could do a whole presentation on takedowns. I do hundreds of takedowns. Traditionally, if we're dealing with a standalone infringing website, it's very hard to communicate with this bad actor, this pirate, this criminal. So we would file the takedown request to the hosting company or sometimes the registrar. But sometimes it's happening on a platform like Alibaba or eBay or Amazon, and then you can do takedowns through their methods. You can even do takedowns on Google Ads, on Wikipedia. Really, there's almost no limit to the website that you could take down. If you see something that's clearly infringing your brand, I'm not talking about a bad review of your product, but someone's taken your copyright, they've taken your trademark, or they're really doing something offside. Unless they're using some sort of quasi-criminal host and they're really trying to avoid any sort of takedown, we can usually get it off the internet. Next, domain name arbitration. If your brand has been incorporated into the domain name itself, you can pretty much always get it back. If it's a .ca, we have a unique procedure called the CDRP. It mirrors the UDRP, but it's just for Canada. And then for GTLDs, of course, you can seek the UDRP, which many of you will be familiar with. Border enforcement. Mark already touched on this proactive tool of an RFA, providing a list of your trademarks and copyrights to customs, no government fee, and then they can keep an eye out. And when they see suspected counterfeit, they call you or whatever agent you've put on the form. They'll call them and say, hey, we think we got something. But if you proactively identify a stream of infringing products, a particular shipper, a particular port of entry, a particular receiver, we can communicate that with customs and they'll do everything in their power to specifically target that shipment, which is powerful because the default level of inspection is very low in Canada. It may only be 1% of shipments coming in. But when we can provide additional information, we can increase the chance that they'll look at that shipment. And finally, Canada has a very strong Anti-Counterfeiting Coalition. This is a nonprofit entity that receives phone calls from victims of online fraud. Let's say you've got a brand, a Nike shoe or a Skechers shoe. Someone went on a website, paid money, thought they would get the half-price shoe, but they just don't receive the product. It's a scam. If they call this number, an investigation will be triggered. It'll be communicated to the payment processors, such as Visa or MasterCard. They have a zero-tolerance policy for websites that are processing fraudulent transactions. And often, this will lead to the demonetization of that website or any other website that's using the same unique banking codes to process the transactions. Now I'll just pass it over to Mark to get into more of the litigation strategy.
So at least the first two. So looking at the first icon, C&D letters. So this is perhaps the most common reactive tool that is in a lawyer's toolkit when it comes to dealing with infringement, be it online or in brick and mortar. The purpose of a C&D letter is to notify the infringer of your rights and to make demands. Now, I could do a whole webinar on various tips and tricks when it comes to C&D letters, but I'll just provide two for the purposes of today. First is to be firm but courteous. Assume that your letter will go viral because in today's day and age, it very might well. And then secondly is to be comprehensive. This is no time to be coy. Unless there's a concern that some of the rights that you want to assert are vulnerable to cancellation, assert all available rights that appear to be infringed and ask for everything that you want. If you don't ask, you won't get it. So you might as well be complete in what you're asking for. So the next reactive tool is legal proceedings. So this is the nuclear option of reactive tools. It can be expensive, it can be time consuming, but sometimes it's the only path available to stopping infringement, and sometimes it is the best path that's available. And it can be a valuable tool in deterring other infringers, particularly if the legal proceeding results in a judgment. Now, I could spend several webinars discussing various aspects of legal proceedings, but for today's purpose, I'm going to highlight just three. So the first is to consider the type of legal proceeding that you're interested in commencing. In Canada, legal proceedings can be commenced by action or application. Actions have pleadings, discovery, trial with live witnesses, so the sort of legal procedure that most US lawyers are familiar with. Applications, in contrast, have no discovery and are determined on the basis of affidavit evidence and cross-examinations. So applications are generally more expeditious and less expensive than trials. And so in cases where you don't necessarily need discovery to make out your case, applications are a good option to consider in terms of a legal proceeding. So the second aspect is, what are the available claims? The standard claims are typically for passing off, trademark infringement, and primary and secondary copyright infringement. But with online infringement, you may want or even need to assert additional claims. You may have claims for importation or exportation of infringing goods, particularly for goods in transit. You may have claims for making a work available by telecommunication, which does not require any actual reproduction. You may have claims for circumvention of TPMs or trafficking of TPM circumvention devices, which, as I said, can put substantial pressure on an infringer because of the extent of potential liability. You may have copyright infringement claims for reproduction of logos and packaging and instructions. You may also have claims for authorizing or inducing infringement. The list goes on. The point here is that you should pause and make sure that your claim is complete and you've thought of all the possible claims that you can assert. The last aspect is, what relief are you going to be seeking? So the standard relief is a permanent injunction and damages. But again, with online infringement, you may want or need to seek additional relief. If you are concerned about losing control over a foreign website, you may want to seek an Anton Pillar order and an interim injunction for the purpose of preserving evidence and property by way of bringing an ex parte motion even before serving your claim. So you're not putting the infringer on notice so that they can shift control over the website to someone who's outside of the jurisdiction. If you do not know the identity of all the infringers, you may want to include a John Doe claim and or seek a Norwich order for the disclosure of the identity of infringers. If you're concerned about money being hidden or transferred out of the jurisdiction, you may want to seek a Mariva injunction. And importantly, Canadian courts, I would say, are at the forefront of jurisprudence in the world for being open to granting orders against third parties and outside of jurisdiction. There's the Google Equistec decision from a few years back. And then more recently, Canada, we were successful in obtaining the first dynamic blocking order in Canada, and one of the first few countries in the world. So there's real flexibility in what sort of relief is available in Canada. In addition, for copyright infringement, you can seek both profits and damages, or alternatively statutory damages, which can quickly add up if you have infringement of multiple works. For copyright infringement, you can also seek wide injunctions covering works that were not the subject matter of the infringement claim. For willful infringement, which is often the case with respect to counterfeiting and media piracy, you may be able to seek punitive damages and elevated costs. The list goes on. So turning to the last reactive tool, which can also be a proactive tool, we have education of consumers. Now, this is often overlooked, but it can be very effective. You can educate your consumers on how to spot counterfeits and on unauthorized sources of authentic goods and services. For instance, this particular product is only available through stores A, B, and C. You can educate consumers on the risks of counterfeits, be they safety or lack of a warranty, lack of environmental controls, etc. And you can encourage brand loyalty through things like proofs of authenticity. In short, you can enlist consumers to assist you in protecting your brand. So next, I'll turn it over to Dan to revisit some of these scenarios.
Thanks, Mark. So you'll remember the three scenarios. So we're just going to wrap up by reviewing them with the proactive and reactive tools that we just learned about. And then we're going to turn to your questions. I see we already have one or two questions in the queue. Please type them into that question and answer, because we're going to get through as many as we can. Scenario one was the domain name troll. What could we have done to avoid the problem? Well, timely registration of domain names. Most countries will publish the filing of a trademark within a day or two, and that allows certain cyber squatters to target those new marks as domain names. And you can't just think about the main one you want, the .com. You need to think about maybe it's the .com, it's the .ca, and a few others. Just one example, we had a well-known automaker. They were launching a new electric version of their car. This was a few years back. They did a press release. We're going to call it this. And the trademarks had been filed 2 or 3 days earlier before the press release, but the domains hadn't been. And when they went to register them a week later, hundreds of domains around that new car name had been all captured by squatters. Now for .ca, we'll just let you know that you either have to be a Canadian company or have an issued registration. That's often hard to achieve. But our firm can register that domain for you and just hold it in a bay until you're ready to receive it once you meet those qualifications. So your trademark issues, or you have a subsidiary or a partner that it's a Canadian entity that can hold it. So that's proactive. Now let's get to reactive. Okay, they've got the domain name. Not so bad. We can get it back for you. Costs a bit more on the back end, but we can do it. So you do a C&D letter, which for cyber squatting is sometimes very simple. Hey, please give it back. We can negotiate the return. If they refuse, there's domain arbitration as a potential option. And here's an example where if your trademark isn't issued yet, the fact that it's been cyber squatted is an online infringement. It meets the qualifications for expedited examination, and we can have you that first office action in a week. You could do a takedown if the domain is being used for a website that's hurting your business, selling counterfeits, pay-per-click, some sort of bad content. And then you can react. There's nothing wrong with continuous improvement, right? You can react by implementing a new protocol. Why didn't we get these domains in good time? Was it just a mistake? Or maybe we update our processes that when we have certain trademarks that we want domains for, we get them right off the bat. Now, every trademark won't lead to a domain name. If the trademark is just a new flavor, or if it's a logo, you wouldn't have a new flavor of bubblegum, let's say. It wouldn't have its own website, right? And if it's a logo, well, domain names can't be logos. So not every mark leads to a domain name, but some do. Flagship company names, big product names, etc. So I'm going to turn it over to Mark to go through our last 2 scenarios, and then we'll hit the questions.
Thanks, Dan. So the second scenario was with respect to the counterfeiter. So you're a company that sells products. You may not have registered trademarks or copyright, perhaps, and now you're seeing counterfeits appearing online and in brick and mortar locations. So what proactive steps could you have done or should you have done? Well, the first was timely registration of trademarks and copyrights, along with proper marking may have deterred some infringers that have a conscience, and also given something to list in an RFA, which is the third point there. Filing an RFA by listing your registered trademarks and copyrights would have enlisted the assistance of customs and may have stopped some of those products at the border or provided you with useful intelligence that you could then use to go after them. You may have already or could have applied some anti-counterfeiting measures. That may have deterred some infringers, or again, at least made it easier for the rights holder to detect the infringement that's taking place. As Dan mentioned, you could register your brand with various brand registries, such as Amazon. And lastly, you could have a good monitoring program in place to identify when and where a problem arises to take effective action. As for reactive steps, if you didn't register the trademarks or copyright in a timely fashion, as Dan set out, you can request expedited trademark examination and file and obtain a copyright registration within a week. You can engage customs. If you don't have an RFA on file, you can put one on file. If you have information about the sources of infringement, you can share that with border enforcement. You can also train border enforcement. So there's the Canadian Anti-Counterfeiting Network, of which we are a founding member, that in pre-COVID days used to at least annually have a conference that would bring rights holders, police, and customs together, and it provided an excellent opportunity for brand owners to train customs officials on how to detect counterfeits and to engage them. If customs are able to help, they want to help, and it's more likely that they will. Next, you can do a takedown, particularly with respect to the online sales of counterfeit products. You can report the counterfeit sales to the Canadian Anti-Counterfeiting Center and hopefully demonetize them, or at least make it more difficult for them to be paid. You can send a C&D letter, which I mentioned. And then, of course, you can litigate and educate consumers. So then turning to the third and last scenario. So this is with respect to the media pirate, where you have a Canadian citizen or resident who is running a website outside of Canada, perhaps on a host that doesn't respect takedown requests, and is making pirated copies of works available through links or otherwise, and then making applications available for cheating on those games. So what could have been done? So some of these we've already covered. An important first step is ensuring ownership of copyright. I cannot stress this enough. It is so difficult to determine the provenance of copyright and ownership of copyright, a decade after the fact. If you don't know who the authors are, if you haven't tracked creation, if you don't have proper licenses or assignments in place. So this is where an ounce of prevention truly does prevent a pound of problems. Proper marking, we talked about, can deter infringers and also remove at least one defense that's available under the Copyright Act. We talked about timely registration of trademarks and copyrights, TPMs. So particularly in this example, where you have the works being made available online and the offering of applications that modify those games that almost certainly circumvent some TPMs or access controls on those games. That can be a very valuable form of intellectual property because it can immediately make the infringer potentially liable for hundreds of thousands of dollars, if not millions, depending on the number of works at issue. And then we talked about RFAs and brand registry already. So turning to reactive steps, we talked about expedited trademark examination, copyright examination, and takedowns. So C&D letters. So this is often required to address media piracy, and it can be challenging to determine the identity of the infringer. So here, a good online investigator can be worth their weight in gold. It is remarkable how much information can be available online. As good as certain infringers are, they often leave digital crumbs which allow skilled investigators to identify them. Often it is necessary with respect to online media piracy to litigate, or at least threaten litigation, to make a media pirate stop. In this particular scenario, proceeding by way of application would be worthwhile considering because discovery may not be required. However, if there is a concern about losing control over the website, then proceeding by way of application and seeking an Anton Pillar order and interim injunction to preserve both the evidence and also to gain control of the website might be seriously considered. Because if you succeed against the Canadian infringer but lose control of the website, it's a Pyrrhic victory. As for claims, in this particular scenario, in addition to the usual claims for trademark and copyright infringement, there may very well be viable claims for making available, for authorizing and inducing of infringement, and for TPM circumvention, as I mentioned, particularly with respect to the mods for cheating. And to give a recent example, of where such a strategy worked, just last week, we were successful in obtaining a default judgment award of nearly $30 million in statutory damages for several major Canadian media companies and broadcasters against 3 entities that were selling set-top boxes that were preloaded with applications that allow consumers to access pirated copies of television shows or unauthorized television streams. This is, as far as I'm aware, the largest damage award of its kind ever granted in Canada by far. The action was commenced by way of action, and there was a John Doe claim, which has been amended numerous times to add new pirates as the plaintiffs become aware of them. And I think it's a good example that shows that the fight against media piracy can be won, and that litigating and obtaining judgments such as this can result in significant deterrence to further media piracy.
Amen. Okay, so let's get into the question and answer. Thanks for wrapping up those examples, Mark. Now, we've actually got a lot of questions in the queue, so we'll just try to take them one at a time. I'll answer some of them. Mark, I'll throw some to you, but if you prefer, you can just toss it right back.
Well, so why don't I start with the first one?
Sure.
Which is, what are some free public online tools that one can use to check availability of logos for trademark registration in Canada? So the main one is the Canadian Intellectual Property Office, the trademark database. So there, if you can do a Google search, you can use CIPO's online database. Now, searching for logos is a little bit trickier than searching for word marks, but logos are they are indexed according to descriptive terms of the logo. And if you restrict your search to design marks, which are logos, and then keyword search for features of your logo that you're concerned about, you can do a pretty good search of companies that have registered such logos in Canada, and by virtue of having registered those logos, are most likely to enforce them.
Yes. And if your description of goods is a little bit unique, an additional strategy is to go onto the CIPO database, and you're going to have to add a series of restrictions. So you're only going to want to see design marks, as Mark said. That'll cut out all the word marks. Then you're going to limit it to live marks. So it'll cut out all the abandoned and expired marks. And then you could type in the goods and services, let's say it was satellites, and you would get all of the design marks that have satellites, but it may only be 100 or 200 if the goods are relatively narrow. And then you could just scan through all of the logos in Canada that have a keyword in the description. Now, that may not work if it's clothing, because they might be hundreds upon hundreds, but that's another strategy. Okay, let's do another one. So someone has asked the question, if we want to license a franchisee in Canada to use our trademarks, but we only have a pending application. This is not uncommon. It's taking 2-3 years to get the applications through. You want to have a registration to get your franchisee license, but it's just taking time. So this person asked, could we get expedited examination, even though it didn't fit within one of your 3 criteria? So let me remind you, criteria 1 is online infringement problem. 2, border enforcement problem. 3, you're ready to sue someone. So the answer is no. They will not accept an edge case, licensee. It's really important. Currently, as launched, this practice notice is strictly limited to those categories. There's a 4th category about priority filings, but it's extremely rare and it doesn't apply here. However, if you can find any infringement of your product online, it would likely be enough to leverage it and say, hey, we've got some online infringements here and we really need our trademarks promptly. So that's the answer to that one. Probably not. But if you can probably wiggle those 3 factors if you can even get a small hook into it. All right, here's another one. I'm going to pass to you, Mark. Could you just expand a bit? Someone would like some expansion on the dynamic blocking order. It's a bit of a new terminology. These things are rare, they're effective. Let's explain it in a bit more detail.
Sure. So let me provide you with some background on what the problem is with injunctions in an online environment. So you might have a website that is selling infringing products, and you get an injunction to shut down that website, but it pops up on another website or on another server. And then it becomes a game of whack-a-mole. And what our courts have recognized it's referred variously in different ways, but we refer to it as the Gold TV decision, is that in such circumstances, a court is prepared to issue an injunction that will bind third parties, at least in Canada, ISPs, service providers, that will block access to new sites as they arise and are making the same infringing goods or services available. And so the dynamic part of that is that you can shift the target, and importantly, it can bind third parties that weren't even parties to the litigation. In Canada, that can be very effective because the main ISPs account for something like 80 or 85% of the traffic in Canada.
Right. When you've got 5 companies covering 90% of internet traffic, and the court orders them to censor out these problematic websites, you can really turn off the taps. Okay, here's another question. Someone's asking, I mentioned something about securing domain names proactively when you file the trademark. And they've asked, do you mean that your firm is going to register the .ca in our own name and then give it back to the client, once their trademark issues? Because Canada has these strict presence requirements. You have to have a trademark, or you have to be Canadian, or have a subsidiary or partner in Canada. And the answer is yes. For good clients, if they're pursuing trademarks, we will just go out and secure the domain name and just leave it. So be in our name. The client can't use it because the rules for .ca says you can't use our proxy to circumvent the presence requirement. So you couldn't just pay some Canadian to hold it for you and then actively use it. But it's different, and I'm very close with the .ca registry in Canada that controls it. If Smart and Biggar one day just decides we'd love to own ShazamT.ca, well, the reason is because our client would like us to own it, but that's our choice. And if we just let it sit and wait for 3 years, and then when the registration issues, we transfer back, it's on board, we charge a fee for it. But yes, that's exactly what we mean for that. Okay, let's do another question here. Mark, if there's one you wanted to jump in on, why don't you?
Yeah, I'll take the next one on the list, which is, can you elaborate on what defense is refuted by properly marking documents? And is there a risk in improperly marking, such as a registered TM when it's not registered? So with respect to the first part, so there's a defense under the Copyright Act that if an infringer doesn't know or doesn't have a reasonable basis for knowing that copyright subsists in the work. So not that what they're doing infringes or is likely to infringe, but that there is any copyright in that work, then there is the only remedy that's available is an injunction, unless you put them on notice and they continue doing what they're doing, and then monetary liability can accrue. But if you properly mark your works with the copyright symbol, then that, at least in theory, takes away that defense, because it puts them on notice the copyright does subsist. In terms of any risk for improperly marking, so I know there is in the US that if you use the R in a circle symbol for a trademark when your mark isn't registered, that there is some liability and risks that can flow from that. I don't know if there is a case in Canada that has found any risk for doing that. However, as good practice, we typically counsel our clients, unless it's registered, you don't use the R in a circle symbol.
Exactly. And in Canada, we have competition law provisions that any false or misleading statement, which includes false marking, can incur liability. But our competition bureau for these kinds of things would just say, oh, we've received a complaint. Can you clarify? Maybe put a little asterisk, registered in the US. or you change it. So the risk of a monetary penalty for false marking would be extremely low unless it was part of some sort of bad faith strategy to deter competitors or to pretend you had something or to influence consumers. But if it's really just a matter of, oh, we were a bit overzealous, it wasn't registered, or that's actually referring to our US mark, it's really going to be probably you'll just get some, if someone complains, you'll get some guidance and you'll have to update it. So that's not a huge risk in Canada. Great. And as far as trademarks, there isn't really a need to put the TM for notice like copyright. It's really just people tend to respect trademarks more when you mark them, and consumers tend to understand more quickly that that's a badge acting as a source indicator when you mark them. But it doesn't really address any defense that someone would have to trademark infringement. Okay, here's another question. What could be proactive or reactive tools, if any, for Canada to respond to the parallel import goods being extensively sold online by different parties? The goal here being to partly protect the exclusively authorized Canadian agent. So let me just summarize that. You've got global rights, you've got your product moving around, and you've got this exclusive Canadian agent. Maybe they're selling Toblerone, Canadian agent for Toblerone imports. But you got Toblerone coming in through Mexico and coming in from Switzerland, and it's really undermining your contract with the Canadian agent. So the answer to parallel imports is not trademark infringement, really. It's not copyright infringement. We had a Supreme Court case on that. It's the smart contracts. Mark talked about it. What you want to do here is try, to the extent you can, to enter into contracts with your different suppliers to say, look, you can't ship to Canada. We have a deal there. So whatever we give you, you should be keeping that to Europe. Now, to the extent that it's just too hard, your product is too popular, or maybe someone literally buys it at retail at a Costco in the US and brings it up to Canada, there's still things you can do. For example, Canadian packaging has language requirements. So you have unique Canadian packaging that meets the requirements. You don't have one of those multi-packs where you've got English, Spanish, and French, and it's kind of regulatory requirement. It's good to go in so many jurisdictions. So you narrow it so that when those gray markets come in, almost by definition, they're not compliant. And that allows you to maybe complain to the border that improper goods are coming in that don't really meet language requirements, or there's many different requirements. And so that's another approach that you can take, is to have Canadian specific packaging.
From a trademark perspective, it's challenging. If the parallel import has different characteristics than the domestic one, and you find that not infrequently with respect to food products, where they're designed to cater to different taste profiles. Sometimes there's different warranties. If that isn't being communicated to the Canadian public, then you may have a claim for a material difference, and to try to stop the parallel imports. But it's very much on a case-by-case basis, and it is challenging to enforce.
And you just triggered my memory, Mark. Apologies, hard to sometimes come up with everything we want to say on an answer. Warranties is one of the ways that some companies do this. They say this product is only warranted when sold in Canada. And so you can have notes like this. So let's say it's headphones. You try to just chalk up the world, and therefore anyone who brings in the headphones in a roundabout way that weren't designed for Canada, on the back of that product, it might say, let's say it came in from the US. This warranty only valid in the US. And for your Canadian exclusive distributor, you're making them their own packaging that says this is only valid in Canada. And so therefore the consumer who buys the parallel import isn't getting warranties, or the product is in some way inferior. Now that's not always desirable, because sometimes that will just annoy your consumers, but these are some of the tricks that you can do. It's really about contracts and benefits, product registration, and things like that. All right, Mark, would you like to grab another one off the list here? We have one or two left.
So sure. So do we have any recommendations for handling non-commercial activities such as criticism or parody? So few thoughts come to mind, and I'll invite Dan to jump in at any point. I think that it's a very case-by-case basis. So like the US, Canada has fair use provisions, at least when it comes to copyright, that are flexible, and so you need to be aware of those. You have to wonder if trying to shut down criticism or parody is going to result in more publicity and eyeballs than just leaving it alone. So that's a pragmatic concern. From a trademark perspective, depending on what the criticism is, if it's untrue, then you might have claims for unfair competition and under Section 7A of the Trademarks Act. Anything else come to mind?
Yeah, no, I agree with you entirely. From a copyright perspective, we have a fair dealing exemption for parody and criticism. So unless the criticism is somehow false and malicious, or the parody doesn't qualify, it's probably okay. But from that trademark perspective, we had a famous case a while ago where Perrier water, someone parodied the trademark and put Pierre Trudeau was our prime minister at the time, Pierre A, the Canadian A. And so it was Pierre A instead of Perrier. And it was supposed to be a parody, but the court said you can't parody trademarks. You're still trying to create the connection, and it's depreciating the goodwill, and it's kind of linking to source. So you can parody copyright and you can criticize for copyright purposes, but on the trademarks, you can't parody. And like Mark said, if you criticize a trademark, it better be true, because if there's anything false, we can attack for false and misleading statements. Mark, I'll leave the last question to you. I see that we're short on time. We have 1 minute left. We'll just answer this question and then we'll call it quits. And thanks so much for these great questions.
So for dynamic blocking, can Canadian courts block websites globally? So yes, in part. So the dynamic blocking injunction can compel Canadian ISPs to block access to websites globally, because that access is being provided to the Canadian consumers through those ISPs. So in part.
Yeah. For essentially, all Canadians will be protected from the copyrighted content wherever it comes from. But of course, it's not going to affect someone sitting in Japan or Australia. Let's call that a day. Thank you so much, Mark.
Dan, and thanks to all our guests. I hope that this provided some useful information and tips.